All right, everybody. So there you have it. Court has been uh, ended for today for this case. I was not expecting that, but you know, I guess they've got the judge might have other things she's got to do on the docket or whatever. I'm assuming they said that this case will go to the jury by midweek. That's what they're anticipating. So we're thinking Wednesday on this. So I assume the defense is going to put on. I know the defense referenced at least one other doctor that's going to be coming in to testify, I believe. And then I don't know if we're going to hear from the defendant or not. We got some interesting information on cross examination about the sequencing of events that were led up to this killing. That the 12 tribe meeting was a triggering event. That she apparently believed that the 12 tribes meeting, that the sermon or whatever the teachings were on that event were or led to uh, I guess her believing that it was being communicated to her that she needed to do this. Then she goes back to the house, and then the shirt gets thrown her way. Clearly, I think, in my opinion, I am completely 100% comfortable with guilty by mental defect. The concern I have stems with what she said her thoughts were in that room, with the awareness of what she was doing, where she apologized to the baby. Um, that is that's a problem. And that, I believe, is going to be um, something that would have to be explained. Now, that doctor did a good job kind of deflecting and explaining, but I really didn't hear the doctor, and I'm going to go back and listen to that direct examination one more time, because I really didn't hear her take up the issue of, she really didn't get into those things. I mean, that all comes out on cross. This doctor just talked about her diagnoses, so I assume there's another doctor that she saw that's going to talk about those things and how it applies to the defense's theory of things. Um, I just think that, and Karen Z, yeah, you absolutely can. If you go into the person, you can block so you can't see. If there's a person you don't want to see their comments, an easy way to do it, um, you can just go in and block that person's comments. There definitely is a way to do that. And you can block them, and it doesn't block others from seeing them. It just means you won't have to see them, and you can go on about viewing the chat otherwise. No, they are not on lunch break, Marjorie Smith. They are actually done for the day. Today was only a half day. Apparently, this judge didn't do like the Ferris judge did and say, "Hey, we have a half day today," or um, and gave a preview of the next day. This judge kept it close to the vest, and just hit us with it out of nowhere. So disappointing to see there would be no afternoon session. I was hoping we were going to get the defense's case. My expectation was we would see most of the defense's case out of the way. There'd be a determination whether she would testify, although I don't think, it doesn't sound like she will, because it sounds like the doctors are going to be able to talk about um, what she said as part of the evaluation. So I think the defense in a situation like this is going to be able to get that information in. But what we heard on cross examination from the doctor is, to me, again, it plays to the idea. And I was talking about my wife. She's been watching along with me this morning. She's a mental health nurse, and she basically said, in her opinion, that there's a difference, that if she's in the realm, these people can be in the realm, kind of like this lady is thinking, okay, the universe is telling me I've got to kill my daughter and take her to another place. She's still conceiving right and wrong in that moment, which Georgia law carves out for her. Now, was mental illness driving her? Well, Georgia law covers that, and that's covered by the guilty by mental defect. So I think the defense has very successfully proven that, and I think that will be where this jury will fall. At this point, I have not heard. I have not really heard enough here for them to say that they have overcome. I think they've definitely risen it. Could a juror find it? Absolutely. Preponderance of evidence. Has that been reached? Absolutely. That is possible. But I think it's going to be very powerful in closing arguments when the state stands up and takes them through this and says, um, "Hey, um, let's look at this. She clearly had a whole battery of mental issues, but she knew right from wrong at that moment because she asked the child for apology. She did web searches. She was looking. She was planning. She was in this moment. Yeah, she thought all these external things were telling her to do it, but it still didn't mean she didn't know it was wrong. She knew it was wrong because she closed the door. She locked the door, and then at the moment that Z comes in, she starts stabbing herself in the chest because she knows it's wrong. Because she knows she's about to go to jail. She wants to make sure she's dead because she knows what she's done is so wrong. That's all in the moment of the act. So this may not be as difficult of a decision for the jury as we think, because I think, to me, they've done a great job establishing mental defect. However, what I think is also has been equally done is that at this point, she knew right from wrong, right? I mean, in the sense that she knew what she was doing was wrong, even if it was a vagueness, but her actions look that way. Then she gets up, she's worried about prison. So it appears during this entire state, she knew what she was about to do was wrong, but she felt the universe was telling her to do it, and she had to do it anyways. Um, so well, Z broke the door down because, according to others around, the baby was crying, and again, I don't know. We really, this is the interesting part about the case. We have really heard very little about what happened at that moment, except through these witnesses. So again, I'm curious to see if that's going to come up. Maybe that's going to be a troubling point for the jury if we never hear more than that. But I have a feeling it's about to become real clear for us on that next witness, because I believe it's Dr. Barrios, I believe was the name of the doctor, is going to be testifying. And that doctor is the one who got a detailed account from Chloe of what happened in that room, of exactly what occurred. And she was able to very vividly remember it and recount it for the doctor. So, I think, I think, I think we're going to see. Now, whether we see Z or not, the state hasn't called him, but the state may call him in rebuttal, because now that they've risen the issue of mental defect, once they realize that they actually have to go in, if the judge says, yeah, we believe they've met the preponderance of evidence standard, which is 5149, right? Could a jury find 5149 if that happens? Now, for them to go across the line and prove beyond a reasonable doubt, because remember, the standard is still here that every member of that jury has to believe beyond a reasonable doubt that she knew right from wrong. So it's not the standard that they have to say, well, it could have. If there's a doubt, and could there be a doubt here? This doctor raises that doubt. So we also have to recalibrate our minds and say, well, she knew, but do we know for certain? Do we know for certain at that moment she could conceive of it? Or does she believe she's in this imaginary world? She has to do this. There's no other way. They've told her that it has to happen right now. She must do this, and she does it. And was right or wrong factoring into that decision? Can a jury in that jury room say beyond a reasonable doubt? We'd have to see. I don't know. Because again, that's going to be that's when the jury gets the law and we'll hear it. I think it's going to be very interesting, very, very interesting to see what the jury does with this. So, guys, for those of you looking for a trial to watch this afternoon, you will be redirected to the Jose Ibarra case. That is going on. So that will be going on for the rest of the afternoon, to my knowledge. And you'll be able to go over there, catch up with that. They had opening statements. They're putting witnesses on. So that's where I'll be over watching that. Also, be on the lookout. I'm going to be replaying the testimony of the lead detective. I'll be replaying these testimonies entirety over the weekend to get a feel. The cult member, you'll be able to hear it straight up, no interruptions, sit right through it. The lead detective and then you're going to be able to get this doctor. So all three of those will be coming out over the weekend for you to review and talk about it. Deanie Cole says, what's a redirect? So what redirect is this. Okay, so the direct examination is when they examine the witness. Then they get to cross-examine the witness. That's when the defense or the prosecutor, whoever's on the other side, will get up and they get to ask leading questions. They get to essentially attack the witness. Now, one of the things on cross-examination is it's yes or no answers. They don't get to elaborate. So the answer is normally, if you're doing a good cross-examination, it's in the questions. So it's like, isn't it true, that when you went down, you saw the gun in her hand, right? You wouldn't get to ask a question like that on direct, right? Now, the witness is going to be told to answer yes or no. They may want to elaborate, but they're not going to be allowed to. Then you're going to get that's when you're hear the judge say, you can clean it up on redirect. So on redirect, they will get the opportunity to allow the witness to explain answers and explain things and clean it up. Mental defect is unable to appreciate the criminality, so meaning she did not know it was a crime to kill. No, well, sort of. That is not how it is in Georgia, though. Okay, because Georgia makes a designation. It would be guilty by mental defect means that she still knew right from wrong, but that mental illness was a contributing factor to her killing the person. But she still knew right from wrong at the moment. That is there is a designation there. Whereas in Georgia, it is guilty by mental defect, but you didn't know right from wrong. In other words, the mental defect or mental illness, all right, was so severe that it precluded the individual from being able to understand what they were doing was wrong. Redirect to the other trial. I'm sorry, Jamie. I apologize. Oh no, redirect. What I mean by that is, redirect it's a YouTube term. So what that means is that when this ends, you should be brought to that other trial. So when I end this stream here in a few moments, it's going to bring you to that trial automatically, so you won't have to go find it. Sorry. Sorry about that. I thought that was. I thought you were talking about redirect testimony, and I forgot I used that term in reference to YouTube. But it means it will take you to that stream without you having to go back out and locate that stream. So all of a sudden you're going to be watching, and if you have it set to automatically go to the next video, you will just suddenly be in the Jose Ibarra case. Anyways, all right. Well, with that said, guys, it looks like we'll be back in session Monday, 10 a.m. Looks like we're going to have a Monday, Tuesday, possibly Wednesday, this thing's to the jury. I expect the verdict will be definitely had by the end of the week. So, also, okay, Melissa. So, absolutely, I can do that. So, yes, the other trial is a bench trial. And what that basically means is that Mr. Ibarra, and this is what they had a hearing about earlier in the week, in fact, he has waived his right to a jury trial. So what that means is that the judge will be the trier of fact. So in the case, so what that means is the judge will be listening to all this. There's not going to be a jury present, and the judge is going to get to make the determination of whether or not the evidence in the case meets the standard of proof beyond a reasonable doubt in his case. And it looks like, that is, one of the big issues in that case is going to be surrounding cell phone info, based on what I saw in the opening statements, that the defense is claiming that he's claiming that his brother did this. So that is what's going to happen. Now, one of the reasons why they would do that in this case, I think it's happening, is because, remember, he's an illegal immigrant, And I guess the concern of the defense, I think, is that that the citizenry could might not be able to overcome their bias. So I think that they're hoping that this judge is going to follow the law. And one of the things that happens, which kind of is an extra requirement on the judge in a bench trial, just so you understand, is in jury trials, you never get an explanation for a verdict. Okay. But when you go to a bench trial, the judge is required to make findings of fact on the record as to support the verdict. Yes, that is the Lake and Riley bench trial. So that is one of the reasons why attorneys in certain cases will say, you know what, let's go the route of the bench trial, because it will require the judge to make a finding of fact on the record as to why he's finding the individual guilty and how that burden of proof was met. And it essentially allows for judicial review. It allows, when you do a bench trial, it will allow the appellate court to relook at that and make sure that the finding was sound and within the law. So it actually it's kind of an added level. Some people might say, hey, I wouldn't. Why would you want to give up 12 people? Again, you're almost sidestepping the whole point of what a jury system is supposed to protect against, because you're going to now have a member of the judicial system uh, come in and apply the law. But there are some things that are present when you do a bench trial. It actually allows for the appellate court to review that decision and to make sure that it was sound. So they will review the entire trial record and affirm that, in addition to looking for errors or errors that the judge made. So it's kind of a it does offer some additional protections, but of course, some would say when you take the decision of 12 and put it in one person's lap, whether or not those extra protections they're going to add in at the appellate level are worth it, well, I don't know. But I think his attorneys basically feel like it would be very difficult to find a jury in this case who would be able to overcome maybe the feelings about him being an illegal and stuff like that. So, anyways, that's where we're at. That's what's going on with that case. So we're going to be over there in a few seconds. You're going to teleport right to that trial. I'm going to make sure that's all set up here before we end this one. I believe it is. And once I hit end, you will magically head over to that trial, and I'll see you over there. And maybe you'll hear me talking over there at the end of that trial. I've got to get caught up. My focus is really on this, so I've got a little catching up to do. I think we missed the lunch break to do that, but we're head over there. So, anyways, guys, I appreciate all of you. I'll see you on Monday, if not over there at the Ibarra case. And until then, guys, let justice prevail, and I will talk to you soon.